It's Laura Frederick from How to Contract, and I'm excited to be here today to share with you another training video on NDAs. Now, we've heard from a lot of people about how they benefited and learned from the past two videos. And the comments are all about how practical they are, and that's really my goal. My goal is to help you learn how to do NDAs in the real world. Because in the real world, we don't have a perfect information set. We don't have a ton of time. We don't have just one counterparty to focus on and spend half a day thinking through all the issues. Often we have to review them in way too little time and with less information than we really would want to have. But that's the reality we live in. So this training is really about the process you go through as you review your NDA and figure out what you're going to change, what you're not going to change. In the prior two videos, I covered some of the practical things. The first is, why do we do NDAs? And talked a little bit about the background of trade secret law and the relationship of the parties. The second video I did was about the 5 most important provisions that I look for when I'm reviewing my NDAs. And today's video is going to be about the 5 things that I look for to avoid in any of my NDAs. These are the things that I always delete or remove. All these videos are based on what I've learned over my 25 plus years career as a commercial contracts lawyer working in big law and in companies like Tesla. So let's jump into the 5 things that I avoid in my NDA. Before I tell you number 1, I want to point out that you'll notice a theme here. And the theme from what I avoid in my NDAs is any provision that is inconsistent with the level of obligations and rights that we are entering into as part of the NDA. NDAs are often a preliminary document when the parties have just started talking to each other. So one of the things I'm always avoiding are commitments that are disproportionate to that level of relationship. Now, some of these provisions I'm going to talk about may be completely appropriate in a corporate transaction, employment, real estate, construction, all those kinds of things. What I'm talking about are your standard commercial deals to buy, sell, and license stuff. Okay, with that, let's kick into number 1. Indemnification. Now, newer lawyers and people new to contracts often are confused by this. They're thinking indemnification is a good thing. It's a great way to allocate liability for something that is somebody else's fault. The problem is at this NDA stage, we really don't have that many commitments to each other. It's just some basic promises not to use and disclose information. When you are sued, if I'm the indemnifying party, I have to step in and potentially defend that case, pay for the judgment. And that, to me, is a completely disproportionate and an inappropriate level of responsibility for a relationship as preliminary as an NDA. Indemnifications should be in your main agreement when you're talking about your transaction. But in this preliminary stage, it's just not right to have that level in a contract. Number 2, limitations of liability. This is hard for some people because you're so used to having a rule that says every single contract has to have a limitation of liability. But the problem is the type of contract we're talking about with an NDA, that standard rule should not apply. You should not have a limitation of liability in your NDA. And let me explain why. With an NDA, we are talking about most likely consequential damages. So typically when somebody takes information and uses it in a way they shouldn't have or discloses it in a way they shouldn't have, the party that's disclosing is often harmed only with consequential damages. So if we have a waiver of consequential damages, that could potentially leave the disclosing party, the one who didn't breach, with no remedy because all the potential damages that they would pursue for a breach of an NDA, for a breach of those non-use and non-disclosure provisions, would have been waived. That's terrible. The way I describe it is it's like a price tag on your confidential information. If you have an NDA, and I had this case where I had a company with a ton of trade secrets, and the counterparty wanted an NDA with a $1 million fixed cap, no exceptions. What I told my client was, are you comfortable selling your secrets to this counterparty for $1 million? Because that's essentially what this NDA would mean. And of course, their value of their trade secrets was in the hundreds of millions. So they said no and walked away from the NDA. That's how important it is. Let's get to number 3, which is intellectual property licenses and assignments. Now, there's a temptation to include IP provisions in NDAs because often we're talking about things that are protected under IP laws, things like copyrights and trade secrets, potentially patent applications. There's this sense of we should address that. We should address how the parties have ownership and what rights they have to this information. The problem is that we do not want that kind of right transfer, the kind of assignment language or granting of permission that we have with an IP license. We don't want that in an NDA because if you go back to the last 2 points I just made, we don't have limitations of liability. We don't have indemnification. We don't have a lot of the bells and whistles that we see in commercial contracts when we're talking about an NDA. And because of that, this is not the right vehicle for IP licenses and IP assignments. If you're at this initial stage and you want to talk about IP, that's a signal that you need a separate agreement. Now, I've done deals where I have an NDA and a limited beta use license agreement, but I keep those 2 documents separate because they really cover separate things. An NDA should only be about non-use and non-disclosure. That's it. We're just talking about an exchange of information and some terms relating to that exchange. If you want to include IP terms, those should be in a separate agreement. Again, depending on what you want to do with those IP terms. But most of the deals, unless there's some kind of beta license, we wait and have the IP licenses and assignments. We put those in the main agreement. Because really, once you're doing those grants, you have to do those grants properly. And they should be in the context of a bigger transaction with all the boilerplate and all the other terms. Now, this answer is very similar to the answer for number 4, which is privacy and data security provisions. These are such important terms to have with your counterparty when you are exchanging any kind of personal information or any information that could be subject to a data breach and raise issues there. And just like with the IP provisions, an NDA is not the right document to use if you're concerned about compliance with GDPR and other privacy laws. That's a data protection agreement addendum amendment. That's the document that has all the right terms that you need for privacy and data security. An NDA does not have all those terms and honestly shouldn't. We shouldn't try and mush together an NDA and a DPA. These are separate documents that should be separate documents. They have separate lives, separate terms, separate consequences. Everything should be separate. So avoid combining those 2 into one. Have a separate NDA. And if you have data that's personal information or something you're protecting because of security, you want to have that covered with a DPA or other kind of data specific agreement. My number 5 is non-solicitation provisions. These are the provisions that say you cannot hire one of my people. Sometimes there's a liquidated damage for it. If you do hire someone, you'll pay me 25% of their first year's salary, whatever it is. These, again, are not typical and not appropriate in my mind in a typical commercial contract setting. If you are hiring a company to do some work and you're just having some preliminary discussions, you have not advanced to the place that you really want to start making these kind of commitments and agreeing to not hire their staff. If you did that with every company that you ever talked to, you'd be really restricted. Also, there's some legal restrictions on when you can agree to those things. Again, NDA is a preliminary document, not a full document of the parties. The one exception to the non-solicitation NDA, where I do see a reason for it, is when you're hiring a talent team. You're talking to a company about hiring their talent team, particularly for professional services, software development, or design, things of that nature. Then I do see some non-solicitations. But that's the only exception I make to the non-solicitation rules in my NDAs. So those are my 5 things that I avoid in all my NDAs. Hope after watching this video and the other 2 videos I made, you're a lot clearer reviewing NDAs. But I want to tell you, this is just the tip of the iceberg. It's just a glimpse into all the things that you need to know to build your NDA expertise. What I really want to do is help you fully and completely master your NDAs. I want you to approach each NDA feeling confident, knowing what you're doing, feeling like you have this. I want you to be that NDA expert at your company where you're the go-to person because you know what you're doing and you're confident on each section, on each line, on each word, what to say and not to say in detail on all the different NDAs that cross your desk. But really, my number one thing I want is for you to feel that confidence, for you to have less anxiety, less stress about when you have to review NDAs. Because I know that feeling. I know that feeling when you don't have time and you don't have time to ask people, you don't have time to look stuff up and figure it out. You just have to get this reviewed. When you don't have that mastery, it's so stress inducing and you just start thinking about what could go wrong, what you might miss. That's my goal. My goal is to help you get that expertise. My goal is to get you there. You can get there with the right training. And that's what I want to talk to you about. In my next video, you'll learn the exact steps that I can teach you that will help you achieve that NDA mastery. The training and program I'll be telling you about has a limited number of spaces and will only be available for purchase for 1 week. I don't want to spoil it, but I'll tell you it's going to be super practical, interactive, like I've never done before, and will suit any schedule. Keep an eye out for that video. But in the meantime, I'd love to hear your reactions to today's training video. What are your 5 things that you avoid? Are your 5 things different from the ones I listed? I'd love to hear about it in the comments. Thanks so much, and keep an eye out for that next video.